Professor Patnaik, and thank you, Pratibha. It's indeed a pleasure to be invited to deliver this inaugural lecture of your litigation series. And I'm glad that you chose public interest litigation as one of the areas of lecture, because public interest litigation has been for some time and is now a very important branch or area of litigation, and which has the maximum impact on society as well among all the areas of litigation. So, and good morning to everybody who's listening in, especially the students. So what is public interest litigation? It's basically litigation which is done for the benefit of either society as a whole or a section of society, especially a section which is disadvantaged. So one can have public interest litigation on environmental issues which largely benefit people as a whole, which can benefit the whole country, the whole world, or which can benefit a very large section of society in a particular place. Suppose it deals with water pollution or air pollution in a particular area. It will certainly benefit at least people living in that area, if not the whole country or the whole world. Public interest litigation can also be on issues of corruption, which again affect society in general. Public interest litigation can also be on institutional reforms of the police, institutional reforms of other investigating agencies like the CBI, etc., which also benefit the whole society. Public interest litigation can also be for the benefit of some sections of society, particularly those who are underprivileged and who are not in a position to approach the court on their own. So, for example, it can be for the benefit of slum dwellers, for the benefit of prisoners in jail, for the benefit of rickshaw pullers, for the benefit of street vendors whose rights are being violated, etc. So in short, or in sum, public interest litigation is litigation for the benefit of any significant section of society, especially those who are underprivileged, or for the benefit of society as a whole. So we have had, since the beginning of public interest litigation in the 70s, initially public interest litigation was largely devoted to environmental issues. Thereafter, so environmental issues could be all kinds, air pollution, water pollution, unhygienic conditions, sewage, etc., or deforestation. So there have been public interest litigation on all of these issues. Thereafter, public interest litigation expanded to various civic rights, civil rights of prisoners, jhuggi dwellers, rickshaw pullers, street vendors, etc. And that litigation to some extent also went parallel to the Supreme Court's expansive interpretation of Article 21, where they said that the right to life does not merely mean the right to an animal existence. It means the right to lead a dignified life and includes the right to have all those basic minimal amenities and facilities which are necessary for a dignified life, such as food, shelter, health, education, etc. Thereafter, public interest litigation expanded to cover areas such as corruption. Corruption, as we all know, is a serious menace to society. So there have been public interest litigations seeking independent investigations, court-monitored investigations into acts of corruption especially in which people in high places are involved, powerful people are involved, and therefore which are not likely to be investigated by agencies which are controlled by the government or by powerful interests. So therefore, that original Hawala case, which sought a court-monitored investigation, that was one of the sort of first cases on public interest litigation on an issue of corruption. It ultimately also resulted in a judgment which ordered institutional reforms of the CBI by directing that the reason why these corruption cases in high places are not being investigated honestly and independently is because of the government's control over investigative agencies like the CBI, which are supposed to investigate these corruption cases. And because if high people or powerful people in the government are involved in those acts of corruption, these cases will not be investigated independently or credibly by agencies controlled by the government. So the court said that we must order some institutional reforms of the CBI so as to free the CBI from the strangulating control of the government. So there have been a number of public interest litigations on issues of institutional reforms of various institutions. Started with the CBI. Thereafter, there was a judgment in 2006 in Prakash Singh's case on institutional reforms of the police in general, police reforms case as it is called, where the court gave several sweeping directions in order to free the police agencies from the strangulating control of their political bosses, by saying that the police chief should have a minimum fixed tenure, that there should be a state security commission which should look at larger aspects of policing in each state. It should have some independent people as well, that there should be a police complaints authority, that there should be a police establishment board dealing with transfers and postings of police officers up to a certain level, that there should be a separation between the investigative wing and the law and order wing of the police, because otherwise there are often conflicts of interest between the law and order wing and the investigative wing of the police. So thereafter, there was important judgment also on civil service reforms by the Supreme Court. There was one judgment in between called the Vishaka case, which is about setting up institutional mechanisms within all organizations to deal with sexual harassment of women in workplaces, etc. There were also cases which led to institutional reforms like whistleblower protection notification, that whistleblowers who blow the whistle on corruption within the government should be protected from harassment by their political bosses on whom they blow the whistle. There are cases which are pending in the Supreme Court regarding institutional reforms of the Election Commission by way of ensuring that the government by itself should not control appointments to the Election Commission. We know that the Election Commission has some kind of institutional independence by way of the government not having any direct disciplinary control over the members of the Election Commission. but the selection of the members of the election commission is entirely with the government. So just as the court ordered that the CBI director cannot be chosen by the government alone, but must be chosen by a committee consisting of the leader of opposition, the Prime Minister, and the Chief Justice of India. Similarly, for the members of the Election Commission, which is an important regulatory institution to protect democracy, the choice of the members of the Election Commission should not be left entirely to the government. That case is still pending in the Supreme Court. There have also been litigations on judicial reforms. We have, in fact, this is one of the unfortunate parts of the history of public interest litigation, that while the Supreme Court has been reasonably proactive in ordering institutional reforms on various things, including the right to information, including transparency of election candidates, in which they ordered that candidates must declare their assets, liabilities, and their criminal records, etc. But unfortunately, there hasn't been any proper judgment of the Supreme Court or the High Courts on institutional reforms within the judiciary itself. We know that the judiciary has serious problems, that firstly, people cannot approach the judiciary without lawyers, and most people in this country are not in a position to afford lawyers. We know that cases remain pending for long periods of time. We know that there is corruption within the judiciary. We know that many judges are quite incompetent. We know that judges are also being appointed on political considerations, on nepotistic considerations. So there are various problems that we have seen with the judiciary as well, for which we have taken up PILs relating to judicial reforms to the Supreme Court. But unfortunately, the courts have not been very proactive on that. That's one sort of failing that we have seen, where we see there is also a conflict of interest of the judges in such matters, because unfortunately what has happened is that those judges, for example, we took up a matter regarding the issue of master of roster, that is the Chief Justice alone being the master of roster and alone deciding which case will be heard by which bench. We feel that this power is such an important power that it should not be vested with just one person. So just as the Supreme Court ordered that the power of selecting judges should not be with the Chief Justice alone or with the government, it should be with a collegium of senior judges of the Supreme Court. Same way, the decision as to which case is to be listed before which bench should not be taken by the Chief Justice alone, but by a collegium of senior judges. Now, we took up that matter, but unfortunately, that resulted in a kind of negative decision, and they just reiterated that no, throughout the Chief Justice has been the master of roster and he will continue to be so. So we have seen that the courts have kind of stonewalled PILs relating to judicial reforms, which is very unfortunate. Now, among PILs, there are many cases which involve several issues. As I said, there are cases involving environmental issues, there are cases involving rights of the marginalized sections of society. There are hybrid cases also, which involve several of these issues. For example, the Narmada Bachao Andolan case, which was about the Narmada Dam or the Sardar Sarovar Dam, which had various environmental impacts by way of submerging large parts of the forest, altering the ecology of the river. It also had many social impacts by way of displacing lakhs of people who were going to be in the submergence area. So it was a hybrid case involving all these issues. Similarly, there have been public interest litigation regarding mining, coal mining, uh, iron ore mining, etc. in Karnataka, Goa, Odisha, etc., where the issues are again a hybrid set of issues involving corruption on the one hand and the sort of illegal mining that was going on, and also involving environmental issues and issues of intergenerational equity, because mining involves cutting of trees, forests, and so on. It also involves pollution of rivers, air pollution, etc. There are cases pending in the Supreme Court involving electoral bonds, the legality, challenging the legality of electoral bonds, which involve issues of corruption, transparency, and democracy. So public interest litigation can involve a large range of issues which affect people generally or large sections of society. One of the things that was done early on by the Supreme Court while it started public interest litigation was to say that in public interest litigation, there will be no issue of locus standi, that anybody who is genuinely interested in raising an issue of public interest, whether it is a general public interest issue like environment, corruption, etc., or even if it is on behalf of a determinate section of society who are underprivileged, who cannot approach the court on their own, then they can approach the court on behalf of society in general or on behalf of that determinate section of society like street vendors, rickshaw pullers, etc., if they are underprivileged and not in a position to approach the courts on their own. The Supreme Court also initially entertained letter petitions, which were not regular petitions filed under the rules of the Supreme Court, but just a letter sent to the Chief Justice or to judges, etc. But now they have stopped doing that. Now they say that a proper petition under the rules of the Supreme Court should be filed by way of PIL. But they have occasionally converted some of these letters or even sometimes newspaper reports into suo motu petitions on the pandemic, for example, or on migrant labor. They did take up these matters recently suo motu on their own. And in these suo motu cases where there is no petitioner, and even in some cases where PILs have been filed by somebody, proper PILs, the court has appointed amicus curiae, that is, some lawyer who is asked to assist the court in public interest. So, who is to virtually act as the lawyer of the petitioner in that case, and is expected to act totally dispassionately. Of course, in every public interest litigation, it is the duty of the lawyer who takes it up to act totally dispassionately and in public interest, because he is espousing a cause in public interest. He is not espousing the cause on behalf of anybody so that he is supposed to only protect the interest of that person or that section of society and not look at the other competing public interests involved. So every lawyer who files a public interest petition is expected to and is supposed to act as an amicus. And he is not even expected or supposed to take fees for doing such public interest cases, because he is doing it pro bono publico, that is, pro bono and public interest. Now, so what is the duty of a lawyer who brings a PIL to court? The first duty is that you must study and you must understand and try and say what is the prayer that you are seeking? So the first focus of a public interest lawyer is to first focus on what is it that he wants? What is it that he wants the court to do? What prayer is he bringing before the court? And therefore, it is his duty to first carefully think. He is bringing a problem before the court, but he must simultaneously present the court with a solution to that problem. So, for example, if you say that, well, there is a lot of pollution in the country, there is a lot of air pollution, there is a lot of water pollution, or there is a lot of deforestation going on. Or if you say that there is a lot of corruption in society, you can't go to the court by just saying that, well, there is a lot of corruption in society, so please do something about it. You have to go, I mean, the job and the duty of a proper PIL lawyer is to go with a solution. You all right? I am asking the court to do this, to order this, and this will provide a solution to the problem of corruption or to the problem of environmental degradation or deforestation, etc. So that's the first job of a public interest lawyer. He must carefully think of not just the problem, but he or she must carefully think of the problem as well as the solution to that problem. He must think about that and bring that to the court. Of course, he may not have thought of the best solution, etc. And that's why when we make a prayer, we always say any other order that the court may deem fit and proper. That's always an alternate prayer, because your thinking may evolve due to the discussion in court or due to further refinement of your thinking on that. The second important duty of a public interest lawyer is to try and get the best available information on that subject. So when you take a PIL to the court, suppose you take a PIL regarding, let's say, illegal mining going on in a particular area. You must try and find out everything that is known or that experts in that field know about it, and have a full understanding of that issue from the best available sources of information as well as the best available experts. That's a very, very important and onerous duty of a public interest lawyer who takes up public interest litigation in the court. He must try his best to get the best possible information and understanding from the people who are most knowledgeable and who are experts on that subject. And it's only with that kind of information and understanding that you can take up a PIL, because what happens sometimes is that if you take up a half-baked PIL on a particular issue, you often end up getting it dismissed, and that unfortunately is often treated as res judicata or a bar, which prevents other people who have much better understanding and information of the same issue and the same subject to take up that matter again in court. So therefore, unfortunately, you see, though my own view is that res judicata or constructive res judicata certainly should not be applied to public interest litigation, which means constructive res judicata is that if you have taken up an issue and you have not raised a particular ground, you've sought a particular prayer, not brought certain kinds of information, not raised particular grounds, and it ends up being dismissed, then they say that constructive res judicata is a bar from other people bringing better information and raising better grounds, that it even bars that. In my view, constructive res judicata or even res judicata should not be applied to public interest litigation, given the fact that very often the same issue is raised by people who are much better informed, who bring much better facts, who bring much better grounds before the court, and therefore it should not result in those cases or those petitions being barred from being entertained by the court just because a half-baked petition on the same issue or seeking the same prayer was dismissed earlier. But unfortunately, some courts do take up, do say that even orders passed in public interest litigation would be treated as res judicata or constructive res judicata. So that's why it's very important to go with the best possible information and understanding. Then, the other task of a public interest lawyer is to understand and to put out very clearly what are the rights of citizens which have been violated, for which he is seeking redress. Because ultimately the courts can only act on the basis of, you have to show that there are some rights being violated, or some provision of the constitution or some provision of the law being violated. So therefore, or that some provision of law is not being enforced. Because every power is coupled with a duty. If, for example, if the police is not registering crimes, for example, right now there is a case going on about hate crimes in Delhi, etc. And if the police is not acting on that, one can take the matter to court and say that, well, the police ought to act, or some other authority ought to act on this. So therefore, you have to go with, by clearly pointing out what is the right of citizens being violated here, or what is the right that you are seeking to enforce, or what is the provision of the constitution or any law which is being violated here, for which you are seeking redress, because only then can the court intervene. Then one issue which often arises is, can the court interfere in policy decisions? I mean, this is an issue which has often been raised in the context of public interest litigation. They say that no, this is a matter of policy, therefore we can't interfere. Now we have to understand very clearly that any policy of the government or otherwise which is violative of the constitution, which is violative of any law, is liable to be declared void by the courts. So therefore, if the government says that no, it is our policy that voting rights should only be with Hindus, not with Muslims, which is what some of these Hindutva organizations are demanding today. So, and if the government says that yes, we have adopted that as a policy, that voting rights will not be given to Muslims or whatever, that's clearly unconstitutional, because the constitution says that you can't discriminate on the ground of religion, etc. And therefore you cannot say that voting rights will not be given to one class of citizens, etc. So therefore that policy is unconstitutional. However, there could be other, because it is often said that courts cannot substitute their own wisdom over the wisdom of an elected government. That is true. If it's a matter of pure executive policy, which does not run foul of any provision of the constitution, any vested right of people, or any provision of law, then certainly it can be said to be a matter of executive policy where the courts cannot interfere, because the courts cannot, or the judges cannot substitute their own views over the views of an elected government. So therefore, Uh, in that uh, in that respect, yes, policy decisions cannot be pure policy decisions cannot be examined by the courts, but certainly policy decisions which are unconstitutional or which are violative of any right or which are violative of any law, that can certainly be examined by the courts. Uh, Another issue which arises is this. You see, today many courts say that public interest litigation has become publicity interest litigation, and that there are now a number of so-called PILs being filed for the purpose of publicity. That unfortunately has become true to some extent, because public interest litigation does get a lot of publicity, and therefore there is a tendency now among people to file half-baked PILs for just publicity, where they don't do much research, where they don't think about the prayers that they are seeking, where they don't think about the grounds on which they are assailing anything, and they just approach the court with vaguely mentioning a problem. So there is a problem of people filing PILs today for publicity. And of course, those should be discouraged. But we are also seeing a tendency of some courts to sometimes impose very, very heavy costs, which are totally disproportionate on some of these petitions, sometimes very fine petitions. For example, I'll give you an example. We had gone to court seeking an independent court-monitored investigation into a CBI FIR which had been lodged, which involved a Chief Justice of the Supreme Court, a retired Chief Justice of a High Court, and some other persons who were go-betweens in what is called the medical college scam. Now, we went to the Supreme Court saying that, look, it is, since a Chief Justice of this court is being investigated, it is not proper for a government-controlled agency, even like the CBI, to be investigating this case, because then the government can use that investigation to pressurize the Chief Justice, etc. And therefore, this investigation must be in the hands of an independent agency, which is under the control of the court. Unfortunately, that petition was not merely dismissed, but it was dismissed with costs of 25 lakhs. By that same, I happen to be the convener of that campaign for judicial accountability and reforms. And we had filed that petition, and it was dismissed with a cost of 25 lakhs by one of the judges, Justice Arun Mishra, who had also held me guilty of contempt thereafter. And also, one of the judges involved was one of the judges who was on that bench, which had passed those orders in that medical college scam case. So a judge who had a conflict of interest in that matter heard that case and decided to dismiss it with costs of 25 lakhs. I mean, a perfectly legitimate PIL was dismissed with, so, and this is an unbridled power. I mean, why 25 lakhs? They could have said 25 crores. It's another matter that we were able to raise those 25 lakhs, though campaign for judicial accountability did not have any bank account or any funds at all. But we raised that money and gave it to the court. But what I am saying is, suppose they had said 25 crores. I mean, they can say anything. So therefore, this is an unbridled power of the courts, which also is a matter of serious concern, because the manner in which this power is being exercised on occasions is a very, very arbitrary manner. It's a very arbitrary exercise of power. So these are a few things that I wanted to say about public interest litigation. But having said that, I just wanted to add this. You see, public interest litigation is one branch or one field of litigation, which is an important field, which has a very, very important, which can have a very important impact on public interest. Uh, there are only a few lawyers who properly and genuinely pursue this branch of litigation with the seriousness that it deserves and it needs. It also requires a great deal of commitment of time. Many of the PILs that I have been involved in have gone on for decades altogether, and it involves a great deal of commitment of time also. But I think it's important for every lawyer, whether you are in litigation or not, to understand and to keep your eyes and ears open to what is going on in society. Because as lawyers, you are supposed to be civilized warriors of justice. And therefore, you must keep your eyes and ears open to all the injustices that are happening around us. And your conscience needs to be aroused when you see any injustice happening around you. And therefore, you need to act and do something about it. So whether you take up public interest litigation or not, it is exceedingly important to at least become what your true vocation is supposed to be civilized warriors of justice. So thank you very much.